Good morning, everybody. Thank you all for joining us. We've got a few folks still working on getting in here from the waiting room. Let's see here. I think we're going to go ahead and get started and trust that person will find their way in when they can. All right. Well, thank you all for joining us today. We are happy to be here with you, and I'm going to start with our normal Zoom housekeeping tips like I usually do. The first request that we have of you all is just that you stay muted unless you need to unmute yourself to ask a question, which you are welcome to do. But otherwise, if you could keep yourself on mute, that would be helpful so that we can cut down on background noise and make sure there is no interference in the sound quality here today. We also remind everybody every week, it's been a while, I'm having to get back into the practice of it here. We remind everybody every week that we are here not to give legal advice, but to discuss general information of a legal nature, of course, but that is widely applicable and helpful to community associations, managers, board members, and homeowners in Washington State. So if you are sending us questions that are asking us to interpret the specific language of your governing documents, or feeling like you've got to give us a lot of specific information about a scenario that your community is dealing with, your question is likely too specific for us to cover here. What we do try to do when we get questions like that is try to find something general within that question that we can cover in a more broad way in the Q&A. Otherwise, sometimes we just have to have Chelsea email you guys back and say, sorry, that's too specific. You're asking for legal advice and we can't cover that here. So please don't get mad at Chelsea when you get those emails, because it's me that makes those judgment calls. More housekeeping tips. As we always remind you guys, probably unnecessarily at this point, but the chat is for questions, requests for clarification, no commentary or arguing in the chat, pretty please. You guys are pretty well behaved, so I'm not sure how much we need that anymore. But I did also want to tell you that we are a little bit light on questions that were submitted in advance this week. So if you do have a question that you've been contemplating popping into the chat, feel free to go ahead and do that, because we will likely have time to get to those today. So I don't think I have anything else to cover, unless you think I'm missing anything, Lisa. I might just jump us right into the questions.
Nope, go for it.
Okay, that's what I'm going to do. All right, first question is this. Do the Wakaiowa open meeting requirements apply to master associations where a condo HOA is a member of the master association in a multi-use building? Historically, a representative of the HOA is a member of the master association board. Condo owners have not been notified or invited to attend master association board meetings. I want to start by saying that this is too specific to answer without a review of the governing documents for this particular community. But in general, we believe that the legislative intent would give every owner of every sub-association within a community the right to attend and to comment at the master association board meetings. The RCW in question is RCW 6490-445. That's the Wakaiowa meetings provision, which is now applicable to everybody in Washington State starting January 1 of this year. And subsection 2 of the statute covers board meetings. And members of a community would have the right to attend the board meetings of any community association of which they are a member. So if they're members of both the sub-association and the master association, they would have rights to attend board meetings for both. There are no exceptions in the statute. However, there are sometimes documents written in a way that says the members of the master association are the sub-associations. So that's where the commentary about needing to review your governing documents comes in, because if the individual unit owners within the sub-association are not defined as members of the master association, then the answer to this question could be different. So I do want to remind you that this is definitely not advice for your particular community, and it sounds like you need to consult with your own association counsel to get an answer to this question, because it could be possible under it's RCW 6490-100 subsection 4 that there is a chance your governing documents could lead to an interpretation, for example, that your community is not subject to the statute, which, again, that determination would require a review of your documents. So it's not a question that we can answer here today. But again, if the owners of the sub-associations are also members of the master association, they would then be entitled to notice of the master association board meetings. They'd be entitled to go to those board meetings, and they would be entitled to participate in the owner comment period at the beginning of those board meetings. Lisa, did you have anything you wanted to add to that?
I think the only thing I would add is that depending on what statute your organization or your community is organized under, these just came into play in January. So it's possible that there hasn't been a meeting. I don't know. I mean, you know more than I do, but keep in mind that these meeting statutes requiring open meetings for everybody just came into play in January. So there could be a little workaround period that people aren't quite up to par on the statutes yet, but that's just an aside. Okay, next question. We are currently governed under RCW 6438, which is, as you all might recall, the HOA statute. We have at least one CC&R that states that the failure of the board to act within 30 days of a request shall be deemed approval thereof. How can that comply with the open meeting 2-week notice requirement if the board only meets once a month? For example, if the board meets on the 20th, then notice and agenda have already gone out to everyone, and an owner puts in a request on the 10th to build a shed in the common area, does that mean if the board doesn't meet again before the 10th of the next month, that that's an approval? So I'll start again by saying this is not legal advice for your situation, and I don't know what your CC&Rs say, and you'd have to ask your attorney to interpret the specific language of that. All that being said, the new statutory requirement that we just mentioned to have specific notice for meetings doesn't get rid of the language that's in your CC&Rs about approval. So there could be definitely some confusion, some concern, and I understand your concern about being stuck with quote unquote approving something because you haven't responded or acted on that request. So the short answer to this is we've covered this before as it pertains to some of the statutes and changes in meeting requirements. I know Ken has talked about it a couple of times, so you can look back for more detailed information on that on our YouTube page. Because it could be seen that no response, as I said, is an approval of the request. Our prior thought was that, you can give a response. A response could be, we're reviewing this and we'll get back to you. Because the question is that an action? Maybe. Is that a response? Maybe. You could, as Ken had said prior, you could deny the request and then reevaluate or review it again at the following meeting that is appropriate with your meeting schedule. Some clients are just scheduling a lot more meetings. So you could have a board meeting scheduled on the first Monday of the month and an ARC meeting scheduled on the third Monday of the month. Or you could have a board meeting scheduled every 2 weeks. And as Valerie and I were talking about ahead of this, you don't have to hold every meeting if there's nothing to talk about. So you can send out a cancellation notice if you have a meeting on the schedule and there's nothing on the agenda and no need to have that meeting. So I think your options are schedule a lot of meetings, cancel the ones you don't need, send some kind of a response to the owner, whether it's an automated response or something that says either we reviewed this and here's our response, there's an automatic denial or it's automatically going to be set on the agenda for the next board meeting or whatever that response is. You can amend your CC&Rs to eliminate that automatic approval language. That would certainly be something appropriate in this type of situation to avoid any confusion or automatic approvals. And you can also, change your schedule to make sure that you're not worried about this 30 days. So again, to just have a more frequent meeting schedules so that you aren't running into this problem or concern, I guess. Anything to add to that, Valerie?
Yeah, the one thing that I would flesh out is that part of why some of our clients are choosing to hold more frequent meetings that are regularly scheduled is that under the statute, when you schedule a one-off meeting, you have to send out written notice in the mail 14 days in advance of the meeting with a copy of the agenda, et cetera. But the statute also provides for if you adopt sort of a regular, like annual or quarterly or whatever you want to call it, meeting schedule ahead of time, that you can send out one notice with all of those dates on the calendar in advance, which eliminates the need for the 14 days before every meeting thing. And the way that you address the requirement to provide an agenda before the meeting is that with your annual meeting notice, let's say you send out a notice in the last half of December that says for all of 2026, board meetings are the first Tuesday of every month at 7 o'clock, and ARC meetings are the third Tuesday of every week. The third Tuesday of every month at 7 o'clock. You would include with that notice not just the schedule of the meetings, but also a general agenda, an agenda for your board meetings, an agenda for your ARC meetings, which would talk about the sort of general order of business, which would start, of course, with your owner comment period. And do keep in mind that committee meetings, when the committee exercises the authority of the board, they are bound by the same rules as board meetings in terms of providing an owner comment period, being open to the owners, et cetera. And then you just cancel the meeting if you don't need to have it, right? So the annoyance of having more meetings on the calendar, I think, can be mitigated for some communities, especially those that deal with a lot of ARC requests. Can be mitigated by the sort of ease that you provide in adopting that meeting schedule. And I did just think of one other thing that might be helpful in this scenario, which is some ARC decisions could be turned into ministerial decisions if you adopt some really specific ARC policies. So if the request is something that is relatively routine within your community, a request for approval to repaint a home or to install a new garage door or whatever, and you already have a really clear set of written parameters for what is allowed within your community when it comes to paint colors and garage door finishes or window coverings or some of the more routine requests, then I think the board could determine that decisions between meetings might be ministerial when they are simply applying a policy that the board has already adopted in an open board meeting, because that does not fly in the face of the legislative intent, which is about transparency with the ownership. It's when you're making decisions on things that have not already been decided in front of the community that you risk running afoul of these open meeting requirements. So hopefully some of that gives you guys some good direction. But I do think part of the answer is the thing that nobody wants to hear, which is you do have to meet more often. The good news is the more often you meet and the more efficient you get about running streamlined meetings, the shorter your meetings should end up being over time. It does take a little bit of time to get used to and to adjust, but it does shorten the time investment for each meeting if you get really good at running an efficient meeting. All right, I'm going to move us to the next question. I know Washington has a law restricting owners from selling properties if they have made significant improvements within the last 12 months. Do these or other laws apply to condominiums? And what constitutes significant improvements? Is it work that requires a permit? Is there an exemption if all work is done by licensed and bonded contractors? Does it matter whether or not the condo unit is owner occupied or a rental, or how long the seller has owned the unit? So I'm going to start by saying that this is not a condo or HOA specific practice area question. The statute in question is not within our wheelhouse. I'm not going to spend a lot of time on this because it's not in our wheelhouse. But I think the statute that you're referring to doesn't actually prevent people from selling properties when they've been subject to significant improvements. What it does is it requires that specific disclosures have to be made at the time of sale when you are within 12 months of those significant improvements. And I think in particular, it has to do with electrical work. So this is really more of a real estate question than it is a condo HOA common interest community question. The disclosure obligations that you're talking about are obligations that belong to the property seller, the owner who is selling their property. This is not a disclosure obligation that is imposed upon a condo or HOA association. And it applies whether the property that you're selling is within a community association or not within a community association. So that part is applicable regardless. But this is not something that creates responsibilities or liabilities for a condo or association or for a homeowners association. And it really is an obligation that belongs to the seller, the individual owner and seller of the property. So I think, I could go into stuff about like condo conversion requirements and restrictions. And, one thing I will say is we would like it if all of our client communities had a requirement that all work performed or all substantive work performed within their condo units, for example, should be performed with a licensed, bonded contractor, that it should comply with code, that permitting requirements should be met, all of that stuff. But I think this is too far outside of our wheelhouse to spend any more time on it. And the real clarification that I want to make is that the disclosure obligations that are imposed by this statute are not obligations that belong to the community association. They are disclosure obligations that are made on the owner who is selling the property. Lisa, did you have anything to add on that one?
No, I don't think so. I'll just go on to the next one.
Great.
My question relates to what became effective this past January 2026, as I think there are multiple interpretations coming my way about the 15 minutes at the beginning of the condo board meeting where owners who are in attendance can go over the agenda and ask questions prior to the meeting. The short answer to this is we talked about this before and we don't understand how there can be any different interpretations of this really specific, pretty clearly written statute for once. Remember that the owner comment period, which is what Valerie alluded to before, which is at the beginning of the board meeting, is really specifically tailored in the statute. And the statute, we already talked about, and I put in the chat that it's 6490-445, but specifically here we're talking about subsection 2E, where it says, at each board meeting, the board must provide a reasonable opportunity for unit owners to comment regarding matters affecting the common interest community and the association. So it doesn't say the agenda, it just says the common interest community and the association. And then it says the board must provide at least 15 minutes at the beginning of each meeting for unit owners to comment about agenda items before the board votes. The board may place reasonable time restrictions of not less than 90 seconds per owner per unit, except that the time per owner per unit may be reduced and allocated equally if more than 10 unit owners wish to comment. So we're talking like maybe 90 seconds per person here if you've got a lot of people. It's very clearly, I mean, that is a pretty clear set aside 15 minutes. No more than, if they're more than 10 unit owners, no more than 90 seconds per person, or not less than 90 seconds per person. It's pretty clear. The first sentence, I don't think I would, like I alluded to before, the first sentence doesn't say just about the agenda item, it says about the community. The second section seems to talk about the agenda only. I think if they're talking for their 90 seconds and doesn't bring up a matter about the agenda, you just let them talk. I don't think you need to restrict it specifically. It's such a short amount of time for your meeting, 15 minutes maximum, 90 seconds a person. There's no requirement that you need to respond to anything that anyone says. You just let them have their say, listen, next person. When that section is over, you go on with the regularly scheduled agenda items that are on your pre-sent out agenda to the homeowners. So I struggle to find out how this can be interpreted differently. It's very clear, 15 minutes, beginning of your meeting, let the owners talk. Don't have to give them any answers, even if they ask for one. Just say thank you. You can note it for future comment. If you feel it's an item that you want to discuss at another meeting, you can always add it. Tell them you'll add it to the agenda for the next meeting. And I think that's it. Anything you want to add to that, Valerie?
No, I think you covered it. And we're going to move on to our next question, but this is the last of the questions that was submitted ahead of time. So again, if you have any questions you'd like us to cover, pop them into the chat. The question is, I'm still unclear on how an association can share annual meeting minutes in a timely way. Is there actually a 60-day requirement for distributing minutes? Since annual meeting minutes can't be approved until the next annual meeting, how are associations expected to handle this gap? There's been talk of releasing them after a provisional board approval at a regular meeting, but I recall Valerie saying she doesn't support that approach. If that's correct, what are her concerns and is there any alternative? It's funny, when I was reading this question ahead of time, I must have just skimmed over that last part because I just was like, oh, my name is in here. So I am going to start by reminding everybody that the requirement to make meeting minutes available within 60 days of an annual meeting is something that's in the HOA Act only. So if you look at RCW 6438035, subsection 1, and it says the association must make available to owners not more than 60 days after the meeting, the minutes from that meeting. The other common interest statutes don't have that requirement. I think it's very clear the only way that you can make meeting minutes available within 60 days of the annual meeting, knowing that the next annual meeting is not until next year, is that you're releasing draft minutes. And I don't think I ever said that I didn't support that approach. I think that's the only way that you can comply with the statute. I think you should mark them very clearly as being draft or unapproved minutes. And you don't need to mail them out to everybody. They just need to be made available if an owner requests them. So in an HOA Act community, what this might look like is your annual meeting takes place on December 1st of 2025. And no more than 60 days after that meeting, you have produced a draft set of unapproved minutes that you don't necessarily mail out to everybody or post on your HOA portal or whatever. But if a unit owner reaches out to you in, February or April or whatever and says, can I have a copy of the meeting minutes from the 2025 annual meeting, the December one? Then you say, sure, here's a copy. Keep in mind that as marked, these are draft unapproved minutes. They will be approved at the next annual meeting in December of 2026. That's it. That's how you comply with this requirement. There's no harm in sending out draft minutes if you are not able to have them approved before sending them out. We have talked, I think, in the Zoom about this multiple times, so feel free to review our YouTube page for other videos where we talk about this. But, we did talk about, I think, at the next board meeting, having the board review the minutes and make sure that the board doesn't see anything like wildly inaccurate in them. And I don't think the board necessarily has to vote to provisionally approve them because the board isn't the group vested with the authority of approving those minutes. That really does have to wait for the next association meeting because it's the association as a whole that has the authority to approve the minutes from the previous association meeting. So I think that's how you handle that. And one of the things that I always think is funny is when we're doing these prep documents for the questions that we get ahead of time. One of us, often Ken, but I think we've all been working with Ken long enough that a lot of us do the same thing. We'll leave a comment in here that says something like, if the owners really care about what's happening at the meetings, they'll actually attend the meetings.
That's a Ken.
That is very Ken, but also very true,
Yes.
especially now in this environment where ample notice is required of both board meetings and association meetings. And a lot of communities are holding these meetings virtually now, which makes it so easy to just like Zoom in your pajamas with a glass of wine or whatever you're doing at night. So the folks that really care the most will attend the meetings. But again, don't be afraid to, stamp or clearly mark them draft unapproved minutes. And then when people ask for them, provide a copy of them. And I think even though this is only a statutory requirement for HOA communities, I would have no qualms telling a condo client to do the same thing, even though it's not necessarily a statutory requirement. So I think that's how I would answer that question. There is a follow-up in the chat which says, should draft copies be included in a resale certificate? I would say no to that. Certainly they're not required to be included with the resale certificate. If you feel strongly that something in those draft minutes should be disclosed as part of a resale certificate, I think you could include that. And again, I just would want to make sure that they are very clearly marked as draft unapproved minutes. Lisa, did you want to add anything on that one?
Nope, I think that's it.
Okay. We did have some other questions in the chat. One is there anything new with the CTA and are HOAs still no longer required to register? There isn't anything new. It is still out there, but domestic corporations are still exempted from being required to report under the CTA. If that changes, we will definitely be writing about it on the blog, talking about it in the Q&A, and maybe even sending out an email blast, depending on the magnitude of the change. And I think most of you are probably already on our email list, which we use pretty sparingly. We send out reminders for the Q&A, and then as larger legal developments come up, we will occasionally send out, a more substantive blast on certain specific topics. If you're not already signed up for that email list, you can email info@condolaw.net to get added to it. I'm going to see, I think there's some other questions in the chat. Any updates on House Bill 2354, which is the Middle Housing Exemption Plus? I'm pretty sure that this has passed the House and is in front of the Senate right now, and I don't think that there has been a floor vote. And the way the legislative schedule works, anything that doesn't pass the Senate by the end of the day this Friday is dead for this legislative session. So the link that you put in the chat when you ask this question does take you to the legislative page for this bill, where you can see all the different previous versions of the bill, but you can also see the action by date in both the House and the Senate. So if it's going to pass, we will know that by the end of this week. And that's the only update that I have right now. Let's see what else we have in the chat. Are there any regulations that prohibit charging late fees and interest when a property owner is currently on an established payment plan? Lisa, do you want to take that one?
Sure. I mean, this is a pretty specific question because we don't know what the terms of your payment plan are, but there are no rules that say late charges or interest can't be charged. I mean, it's up to, your governing documents, statutes, et cetera, that allow for interest and late charges and things like that. But if you have an agreement with someone in a, hypothetically speaking, that says that late charges and interest wouldn't be charged while they're under a performing payment plan, I suppose that could be part of your terms, but I am not unaware of something that restricts those from happening, at least in the statutes that we deal with, when an active payment plan is going on. It just depends on your governing documents.
Yeah, and the only other thing is depends on what written agreement there is between
Exactly.
the owner and the association, if any. So
yeah, I mean, your collection policy, for example, could have restrictions on that that we're unaware of for the purposes of this conversation.
Yeah. The only thing that I will say that is sort of tangentially related to that is do keep in mind the requirements that started January 1 of 2026 for specific delinquency notices, which also limit your ability to charge late fees, interest, and admin fees until you have sent a notice that complies with the new statutory requirements. And if you're curious about what those are, look back 6 weeks or so in our Zoom, YouTube links, and you'll see we've talked about these statutory changes really extensively. There's another question in the chat that says, for clarity, is it true now with changes on January 1, 2026, that no emails or texts for communications, not voting, among board members in planning for community? So I think what the question is asking is, are board members prohibited from texting each other about association stuff, even if they're not voting by text or by email? And what I would say is the only way to answer this question is to ask yourself whether the communications that are taking place outside the board meeting are a violation of the legislative intent behind the open meeting requirements. And the legislative intent is just that the substantive discussion and decision-making that the board does on behalf of the community should take place not behind closed doors. So if you are texting sort of incidentally about topics related to the association, but you're still doing the bulk of your actual substantive discussion and decision-making in your open board meetings, then I think it's less of an issue. If you are emailing all of the conversation and the pros and the cons and the arguments and the discussion about a particular decision that you're going to make ahead of time, and then not having any of that discussion in your open board meetings and just taking a vote, then I think you run the risk of running afoul of that legislative intent, right? I also think we all have to be aware, and the legislature, I think, is maybe less aware of this than we wish they were, but there are things that come up that are more time sensitive in nature. There are leaks and there are fires and there are other time sensitive, urgent things that come up within a community that do require some communication or even sometimes decision making between board meetings. I think what you need to do when you're dealing with a scenario like that is again, of course, keep in mind the legislative intent here, but also you have to weigh that against the need to preserve the property and prevent damage. The emergency provision that Kiowa contains about holding meetings on shortened notice or dealing with emergencies that arise when you can't get a meeting scheduled does keep that in mind. So let's assume, though, for the purpose of this question, that we're not talking about an emergency. We're not talking about a sort of sudden, urgent issue that must be dealt with quickly. If you're emailing and texting sort of incidentally, not in great detail, and you're not doing it to the exclusion of holding that discussion in the board meetings, then you're probably okay. The last thing I'll say is, as Lisa mentioned already, not all these, but these particular statutory changes are new. They just went into effect less than 3 months ago. And we don't know how courts are going to interpret all of this. What I can say, though, is that the Kiowa restriction on board discussion and decisions outside of board meetings has been around since 2018, and Kiowa communities are functioning within this structure just fine. So this is definitely a scenario where the shift from the way you've been doing business to this new way of doing business, huge growing pains. It is a pain in the butt. It's going to feel really weird and clunky and take a lot of effort for maybe a few months or so. And then once you get used to it, I think it will feel like it'll feel a little bit more like second nature, just because you will have gotten used to that transition. Change is hard. Humans are not wired to like change. Even if the change is something that we think is positive and generally a good thing for our communities, it can be hard. And so I would say give yourselves some grace for the fact that it's annoying and a pain, and you're going to make mistakes. As long as you're operating in good faith and doing the best that you can to bring as much of that discussion and for sure the decision making into your open meetings, then I think you're complying certainly with the spirit of the statute. And then as court cases come out that further refine and interpret these statutes, we will definitely be talking about them here. I just don't know how quickly that's going to happen, right? Because by the time an appeals court case comes out, and it has to be at the appeals level for it to be binding on everybody who's looking at these statutes, that's at least a couple years away, assuming litigation starts relatively quickly based on these statutory changes. And since we haven't seen a whole lot of that from Kiowa, which has existed more or less as it's currently written, for quite a while, I'm not sure if and when we'll see that kind of litigation happen. Those are all of the questions that were popped into the chat. And I guess part of my question, Lisa, is do you think we have time to cover this little primer that's in here? And do you want to do it? I should have asked you ahead of time.
I can start it if you want. I mean, I think it can be fairly quick.
Okay. All right.
Let me get there. The question was one that kind of came to us from other questions, that come into our office periodically. And basically it is, what do we do when one owner contacts the board and demands that the association sue another owner, a neighbor of this person, for some violation, right? And this comes up a lot. An owner will come to the board and say, so-and-so is doing something that is either against the rules or annoying me or whatever the thing is. I want you to enforce that, please, board. And the short answer when this comes to you is that you're not obligated to enforce a neighbor-to-neighbor dispute, but you do have a duty to investigate, and you have a duty to take that person's complaint seriously if you're the board and look into it. And then you can issue your response. And so our general advice when this happens, when someone comes to you and says, I need you, board, to take action against my neighbor, the first thing is to acknowledge the receipt of that. Don't just ignore the email or the note or whatever, or the person talking at the beginning of the board meeting, whatever the thing is. Acknowledge receipt of the request of that owner. And then encourage those two owners to talk, whether that be informally or whether you enlist something like the mediation program that WSCAI has, which is fantastic and very affordable. I think it's something like $200 a person to be involved in. You can find that on their website, but encourage them to talk and try to resolve the dispute. And the third thing is investigate. Look into it and make sure you're meeting your duty of care that was required. We've talked a lot about the case of Risk v. Angel, where you've done adequate inquiry and you use objective information. So if it's a noise complaint, maybe you need to sit outside there or sit in the unit and hear if you can hear it. Use a decibel meter if that's appropriate, or whatever the thing is, use some kind of inquiry to look into whether or not to the dispute. Yeah, like I said, it might be a hearing or it might be a investigation where you do something where you sit and listen. It might be that you have both parties in to the board and have a hearing and have them both state their case to the board. Once you have all that information, look at your CC&Rs, look at your governing documents. Is what this complaint is about something that is covered as a violation in your rules under your governing documents? Because that's a big question, right? Is this something that you already have some kind of structure to respond to? And then tell the owners, hey, we've looked at this. This is either a violation of our rules, and this is what the repercussion of that is, or B, this is not a violation of our rules or governing documents. And then make sure you document that decision. So whether you're having a hearing in front of them or and you put that on the record at the board meeting or you send a letter to the parties, whatever it is, document the decision of whether you found that to be a violation or not of your governing documents. Ken had an aside that he likes to kind of make sure there's steps, make sure you've given the steps of what you did. The board received a complaint. We looked into it doing X, Y, or Z. We looked at our governing documents and this is what we found. So, those of us who are lawyers, we have this IRAC thing in your head: issue, the rule, the application, and the conclusion. Make sure you've got that all laid out in there. And then, as appropriate, decline to take enforcement action if that's the correct approach. Probably because the board doesn't have, if this is someone asking you to sue the owner, the board doesn't have the legal authority to do so under the statute above, or the statute we talked about. The board has, as we've talked a lot about in other Q&As, a duty, has some duties, and they have discretion. And they have discretion to make decisions in the best interest of the community. We've talked a lot about that. You can look at 649405, describes how the courts would probably interpret the board's duty. It might not be directly applicable to your community because you might not be organized under WCIWA, but we think that lays out some pretty helpful information that a court would probably look to determine. And I think 2 weeks ago in the Q&A, we specifically discussed this statute and those things. I can read that, Valerie, if you think that makes sense, but I think that is where I'd look. But I think that as a whole is the best practice. Take it seriously if an owner comes to you. But it may be that you do not have a duty to act further than responding to the request and investigating investigating whether or not there is some kind of a complaint or an actionable violation between the owners. Anything you want to add to that, Valerie?
The only thing that I like to emphasize is that the board does have the discretion to decline to enforce if it's not in the association's best interest. However, I would also emphasize what Lisa talked about, which is documenting your process and arriving at that conclusion, right? What you don't want to do is just ignore things or not document, because one of the things that anybody who has spent any length of time around any of us in our firm has heard us say ad nauseum is that if it isn't written down, it didn't happen. And if you can't document your investigation and your process, then down the road, if the association is sued, for example, for failure to take action, it's really hard to prove after the fact that you did things when you weren't documenting them as you went through the process. We have a couple of other questions in the chat. One is, under the statute 6434, does a board have a duty to inspect the interior of units for leaks, mold, or other deficiencies if the governing documents are silent on the issue? There's no statutory obligation to just randomly or at specific intervals inspect the unit interiors. And also, there's no statutory entitlement, absent something in the governing documents or an emergency or some other situation like that, that the association has the authority to enter individual units without owner permission. Some of the exceptions that I can think of are that, like, there are many multifamily buildings that have building-wide fire suppression systems in them. And so entering the unit to inspect the components of that might be inside of the unit to determine that the system is functioning the way that it is something that an association may be entitled to do if they're giving proper notice to the owners, et cetera. But you don't just have some kind of random and affirmative obligation to inspect for this stuff absent a reason to do so. Now, let's say you're in a stacked condominium building and somebody on the third or the second floor reports a leak coming in from their ceiling and there's a third floor unit above. Then the question becomes, what do you do with that report? What is your obligation to try to investigate and determine where the leak is coming from? That would trigger, I think, an affirmative obligation on the part of the association to, at a minimum, investigate the report of that leak. Perhaps the person who reports it allows the association or a vendor to come in, take a look at what's leaking, and try to sort of eyeball from inside that unit where it might be coming from, and then trace the source of the leak to its origin and stop the leak so that you can prevent further spread of things like mold. I do think also one of the things that I would like to say is that there is a lot of hysteria around mold. Maybe that's the wrong word. There's a lot of fear and a lot of upset around mold. We live in the Pacific Northwest, y'all. There is mold and mildew everywhere, and the vast majority of it is not dangerous to humans and pets. I think a lot of folks assume any mold is toxic mold, or that if it looks black, then it must be the toxic black kind. And neither of those things is true. Most of the molds and mildews that we encounter in the Pacific Northwest are not dangerous. Certainly they're not pretty, and you want to identify it as an issue and address it when it happens. But I think that a lot of the fear around mold is sort of blown out of proportion. So that's an aside to the question. But absent a report of a leak or something specific in the governing documents or other circumstances sort of outside of our possible knowledge in this Q&A, there isn't an affirmative obligation to inspect units for things like this. Lisa, did you have anything you wanted to add to that?
No, I just saw the other question about smoking being
what about the issue of smoking? And there is really no evidence of exactly where it's coming from, but owners believe it's coming from a specific unit. Well, very recently, I want to say within the last 6 weeks or 2 months, we actually had a really similar question that had to do with, I think, marijuana smoke. However, Washington State, marijuana is legal. And the answer to the question of what to do when there is smoke emanating from a unit is the same, whether it is marijuana smoke or tobacco smoke. So what I would say is, number one, for a more in-depth answer to the question, look back. I think actually it might have been in the last 2 or 3 weeks, and see what we said about the marijuana specific question for this. As you all know, condo associations don't have the right to restrict smoking within a unit unless that right is codified in the CC&Rs, the declaration, or a recorded amendment to the declaration. Smoking is one of those things that's considered a use of the individual unit owner's property. And without an amendment to the declaration, you can't restrict that use. So depending on the nature of the smoke. Oh, also, I think it's important to note that Washington State has, I think there's case law that specifically states that smoke is not considered a public nuisance, or is not considered a nuisance under common law in Washington State. So you have to, I think, if neighbors report that there is the smell of smoke coming from the vicinity of a certain unit, I think you go back to the board obligation to investigate when there's a report of a potential issue by your unit owners. But I also think you would do well to consult with your association attorney to determine not only what your obligation is, but also what limits limits there are on your ability to take action. And I think one of the best ways to handle a situation like this, if you can identify the unit from which the smoke is coming, is to try to work directly with that unit owner and the occupants to do things like determine whether ventilation fans would be helpful, whether sealing some of the cracks through which some of the smoke can escape, whether providing a smoking area within the community that's away from the units might be a helpful way to address this situation. So I think a cooperative approach is often more productive than a compliance-based approach. And I don't think you can just fine someone because there is the smell of cigarette smoke coming out of their unit, because there's no violation. Because it's been found to not be a nuisance, you can't use the general nuisance provisions in your CC&Rs or your declaration to call this a violation. So that is some really general sort of like 50 or 30,000 foot view commentary on the issue. Definitely go back a few weeks to find the question that had been asked about marijuana smoke, because in Washington state, we treat them essentially the same. And if you need more specifics, you would need to consult with your association attorney about that one. Lisa, did you have anything you wanted to add?
Nope, I think that's it.
I think we are going to just call it for today because we're out of questions in the chat. And I think ending early is not a bad thing every now and then. So thank you again all for joining us. We're glad to have you here, and we will see you next time. Bye, everybody.
Bye.